All right, we're back in Senate Judiciary. We have Judge Zelny to provide some testimony real quick. Want to ask about within the ceiling, but there were also a few other points I just wanted to cover briefly since we're during the final stages of this. Just going to page 25, the thing that we've been discussing locally now, which is how people can access or who can access records. Judge, if you could provide any of your thoughts regarding the inquiry process. We did make some suggestions, providing that it's rather than an inquest, it's providing an affidavit. That just makes more sense compared to what an inquest actually is. Do you have any thoughts on that first piece?
So, Tom Zonay, Chief Superior Judge, good morning. The language you're talking about would allow, it would be required by the state's attorney. Generally, when there's an inquest, the judge will require that it be supported by an affidavit to establish that a crime is under investigation. So this provides a standard that is somewhat different than the normal inquest standard. The normal inquest standard is that the court may commence an inquest for any matter under investigation. And what your language that has been added here does is it says there has to be a reasonable suspicion. You're giving a standard. And so I think that will work as an overlay to the inquest, meaning that it's not a fishing expedition. And so I think that that is something which can work. My understanding is that there's not a large number of these, and so I can't say that there will be a significant impact on the courts. If that changed, I could let you know in the future. But right now, I think that's something that could work.
Thank you. And the next piece, right below that, regarding defense attorneys, rather than holding a hearing, would it make sense? Well, I guess it's a policy decision, but having it be on par with what state's attorneys can do in terms of, state's attorneys can apply by providing an affidavit, which a judge may or may not grant, and defense attorneys, I think, should also be able to provide a petition with a sworn affidavit, which a judge may or may not grant. Do you have thoughts on changing that language, page 25, starting with line 18?
I would suggest that if you add language that says the defense attorney may file a petition, supported by a sworn affidavit with the court for purposes of accessing a sealed criminal history record. And I would get rid of the language about the court shall hold an ex parte hearing and utilize language that would be to the effect of the court may grant the petition ex parte and shall grant access to the record upon finding that. And by using the word may grant ex parte, that provides the court flexibility that the court may decide to do it on the papers. The court may decide to hold a hearing. The court may decide that something is a little different here. We want to involve the state's attorney or the attorney general to get involved. So it provides flexibility for the court in that situation, but also in something that I think would be it's a clear situation of, of course, you're going to grant this. We don't need to burden the attorneys and the courts with additional hearings. So it could be done in papers.
Thank you. Michelle, just wanted to check in if you grabbed that language or if you heard that.
I think so.
Great. Thank you. Okay. And regarding the exigent circumstances that we have on page 26, starting on line 3, does that make sense? And is that a does it make sense? Do you have any thoughts on whether or not that's
it's a policy decision, and it's certainly understandable. What you're saying is that there might be circumstances where the normal process can't be filed that are exigent, where you've defined it as a compelling need to act swiftly to prevent imminent danger to life. It's not, well, it's more convenient to do it tonight as opposed to waiting a week, or I'm going on vacation as a law enforcement officer and I don't have time to do it next week. I need to do it now. So it does provide a standard. Experience will tell us in the future whether or not that standard is one that is subject to abuse or not. But it does provide a standard, and it does provide a remedy if someone violates that standard.
Thank you. And the next, well, actually, on those topics, committee, any questions or comments? And the next piece is Senator Ohosky's question / comment regarding tipping the ceiling, and so let Senator Ohosky raise that.
Yes, so I read the report. I think we talked about this briefly last time about sort of the idea of petition the ceiling kind of big picture. And what I'm curious about is the impact of a narrow petition the ceiling for things that are no longer crimes. And I think my thought is there's a retrospective act part of that I think would be nice to know if there's a ballpark, how much time it might take, can we put that in place so it goes into effect 3 years from now? But there's also sort of prospective, if something becomes decriminalized or no longer a crime in the future, I would want to have sort of that petitionless process. And ultimately this comes from the space of, I don't believe that it is fair to put on lay people to pay attention to everything we do in this building and know, oh, that's no longer a crime. And I don't believe that they should continue to carry around a criminal record because of that. And so putting the onus on those who actually know to take the action to expunge that. And so that was a much narrower use of petition the ceiling than in the report. So I just wanted to hear your thoughts.
So that's essentially what would have happened with marijuana.
Mhm.
And in the report on page 3, it details how we currently handle what we'll refer to as petition the ceiling, and that is what you refer to, Senator. That is, someone doesn't need to know. We don't need a defendant to say, "Well, I agreed to paper and I saw this." The court takes care of it. The process starts with the court. With the marijuana convictions, we had over 10,000 cases. So a significant amount of cases. That took a significant amount of staff and judicial resources. We utilized retired judges, and we were dealing with a lot of historical convictions. And so that addressed that. If we started something, for instance, and said, okay, since something's no longer a crime, it's difficult to assess exactly what the resource drain would be or the resource requirements would be. Because if it's something that's no longer a crime and there's 20 convictions, I don't think that's going to be a problem. But if it's something where there's 20,000, which I can't, to me, marijuana would probably set that as high as you can go, something that you would reasonably think might be decriminalized. I can't think of anything else that would get us to that level for a certain type of conviction that would come to mind right away. But if it was, certainly the courts could, if the legislature enacted a statute in the future that says this matter is no longer considered a crime, and you can put a statute in that says that the courts have to seal all records by a date certain. Again, like with marijuana, we could look at that time and assess what is the cost in terms of staffing and resources, but without knowing what that number would be, it's difficult to say what it would look like. But can it be done? Yes, we've done it, but it was a significant undertaking. If it's something that's significantly less in terms of convictions, again, I don't think it's that type of impact, but it can't tell. But we can do it with the proper staffing and judicial resources.
Of course. I always want to make sure you have proper staffing and judicial resources. That's hopeful. I mean, I still stand pretty strongly in the opinion that we shouldn't be asking regular people to be paying attention to everything we do, and they shouldn't have to walk around with criminal record, things that are no longer crimes.
And we do, for instance, if you have a plea agreement, the charges are dismissed. We do the sealing after that. So we do have petition the sealing, as you point out, ongoing for the cases that are there. But it's not taking a large group and saying, okay, now these cases we're going to look retroactively. That's going prospectively.
Yeah. Okay. No, and this is sort of a little bit of both, right? It's the retroactive things that are in the historical, not a crime, but also prospective for things that become not crimes. But it is good to know that it is doable, and there are some sort of remover processes already in place.
If there was a list, if the legislature said, okay, we want you just, here's a number of crimes, if we did X, if we decriminalize these or whatever those crimes are, we should be able to generate reports that will tell you what the number of cases are. And that will then enable us to give a better assessment of what we look like.
So I think maybe I'm just slightly confused or unclear. So you have language that you want to propose for petitionless sealing that is workable and
I mean, I can certainly ask for language, but yes, I would like it. I would like for things that are no longer crime to be petitionless and expunged, which we do have. The expungement we have in the bill. The petitionless, it currently says they may petition.
What would need to, what I would suggest needs to occur is if you have crimes that are no longer crimes, and the legislature wants to be sealed, like we did with marijuana, or the statute should say the following crime, the court shall by this date seal the following convictions for the following convictions for whatever. So to let us know exactly what it is. We can't be guessing, if you will. We all need to be on the same page, exactly what you want us to seal. And that way we can also come back and say, that's 20,000 cases. That's not something we can do in that time frame. If we came back, if you gave us a list of the cases, the statute said these cases, and there was 100 of them, and you had a year to do it, say, I'm pretty sure we can do that. So it's going to depend on what you identify as what is being sealed, not a category, but actually these cases.
So I'm hesitant to make a list because anytime we make a list, we inevitably forget things on the list, which is why I like the category of if the behavior is not criminally, if the underlying conduct is no longer prohibited by law or designated as a criminal offense, like, and this goes to my point as to why it should be petitionless. I don't know what all of those things are. And so I'm not going to know if we pass this that, oh, I actually can get a petition to have this removed from my record because it's no longer a crime because I'm not an attorney, I'm not a judge. I don't know. And that's sort of why I prefer a category, not a list, because we will leave something off the list.
The difficulty with that is that the obligation then goes to the courts to try to go back to the research and figure out what may no longer be crimes. We don't keep track in our data system of this is no longer a crime. Honestly, if we have the conviction, we don't go back and remark that and go, by the way, it's no longer a crime. We only keep track of what the convictions are. So we would need to know what categories to run before we could run that. We don't go in and make that subjective assessment of each. Go, okay, look at this one. We don't have that. And if something's left off, my thought is if it's identified, we catch it the next time. We make the best effort we can to get every case, because that we build transparency, to build the ability of individuals to understand exactly what happened. If a litigant, if the defendant looks at this bill and says, oh, I wonder if my conviction is going to be there. I wonder if they're considering mine to no longer be a crime. That doesn't provide the type of clarity to everyone, but if it says, oh, a violation of 13 VSA section, whatever, is no longer a crime, they know that they should know that's what they had. And so that, I think, really works much better for the transparency and the clarity that the legislature is directing the court. This is and the governor signs it. This is what we want you to do.
so is it more of a suggestion that whenever something is decriminalized in the future, that there be a provision on that bill's directing the court that this specific statute is no longer, this specific offense is no longer a crime? Or are you suggesting something different that would be included in this bill?
I think that in the future, when you have a bill that comes out that says something is no longer a crime, I think if the intent of the policy is we want anyone who is no longer a crime prospectively, but we think retroactively it shouldn't have been a crime. We're changing that, so we want to have it. We want to at least have it sealed. I think it's important to let the court know, and then the court can act on it. I think each time we go over the bills each year, We know it's there and we address it, to make sure it's taken care of. And for instance, it also provides for reporting back. We come back to the legislature and say, Judge, how many cases were there that fit under act whatever, for sealing? Did you get it done? And that provides the accountability mechanism for the legislature, for the judiciary, to make sure that we've done what we were asked to do.
Thank you. I know you have to run a few minutes ago, but any committee, anything further on this?
For Judge Lomé, you mean, or for?
For Judge Lomé.
I don't know.
I don't know, anything.
Not for Judge Dunn.
Thank you.
Thank you.
Appreciate it. We have Martin coming, or Representative Young, coming in 15 minutes.
She's not gonna be there for me to spend quality time with them.
Well, no, for the next 15 minutes, I suppose, but,
We'll see.
so while we're still on committee, thank you. Thanks for coming in on short notice. Yeah, you-
My pleasure. I was, even if I wasn't in town, I would have been able to do it remotely, so.
Thank you. Some thoughts near the light. Yes.
I think we're almost there. I understand the senator's concern. Listening to the judge, it appears though, unless we're trying to put something in that nobody seems to know exists as far as the laws moving forward. I don't know why it can't be addressed on an engagement basis as those laws, whatever they may be, are no longer criminal offenses.
I mean, I'm gonna be a no if people have to petition to get things that are no longer crimes removed from their record. I don't think it is acceptable to ask people to be paying attention to what's happening in this building to know whether or not they can get it removed from their record. I think that the onus should be on the judiciary to remove it.
I think I'm still unclear if we're directing the judiciary to automatically expunge things when they're decriminalized. I don't see how it's still on the defendant.
That's not what this does.
Right, but when crimes are being decriminalized and we're directing the judiciary.
That relies on some future body to do that every single time. I think it should be law that that is what happens every time.
So how, I mean, based on everything here, I don't get how it would work. Okay,
I mean, if you can put it in everything that's decriminalized, I see no reason why it can't be the underlying law that when something is decriminalized, that is the process you go through.
because how would the courts know when it's decriminalized and what cases fall under that category?
You would tell them in the law. But if the underlying law is that onus is on them, so the way this passes in every single thing you decriminalize, you have to say, oh, and also we want all the records expunged. If this goes forward and says if something's decriminalized, the records are expunged, it is then it's more automatic that every bill is going to identify what to be expunged because the law says that it has to. When cannabis was decriminalized, it was a huge to-do to get all of the previous records expunged. And plenty of states decriminalized cannabis and didn't expunge previous records. And it's a huge injustice when that happens. And so I want something on the books that's not relying on some future group of people to do the right thing.
I appreciate the concerns, but I don't understand us addressing something that doesn't exist really. What if we're addressing what if possibility here? It's a gray area, real gray.
Senator Adams?
Did I hear Judge Zoning also say that he needs a list to go off of, not just, hey, if you do something, we'll do it. If you decriminalize something, we'll just do it. Doesn't he need a list, so we have to act on it
That's what I.
down the line?
Well, that is my understanding as to what he wants retroactive clearing.
Well, I guess I misunderstood him or misheard him, because I thought he meant, just because you decriminalize something, we're not just gonna go out there and.
Well, right, but if we tell them they have to, then it's the law and they have to. Like, that's my point. Just because we decriminalize something, they're not necessarily gonna go through and clear the record to what they should.
So then the suggestion is to say in this bill that if something is decriminalized in the future and the legislature orders that it be expunged, then the judiciary will expunge whatever that future criminalized offenses.
I would take out the language of if the legislature orders it expunged. If something is decriminalized, it should be expunged. And it should be automatic for the person for whom they have a criminal record for something that's not a crime anymore. What I'm explicitly trying to prevent from happening is the legislature getting to decide, like, we're actually going to let people have criminal records for this thing that's no longer a crime.
Okay. Well, we have Martin coming, Representative Malone coming in about 12 minutes or so we can take a break. Till then.